Thank you so much for joining us this evening, everyone. I'm Victoria. I'm a lawyer and program coordinator here at CLIA. Thank you so much for joining us this evening. In case you're not familiar with CLIA, the acronym stands for Community Legal Education Association. We are a charitable organization here in Manitoba, and our mission statement is unknown rights are not rights at all. So we aim to bring information about the law and rights to people across Manitoba. CLIA is located on Treaty 1 territory on the traditional lands of the Anishinaabe, Cree, Oji-Cree, Dakota, and Dene peoples, and on the homeland of the Métis Nation. And while we do work primarily in Treaty 1 territory, we also work with and serve communities located in the territories of Treaties 2, 3, 4, and 5. Tonight is our first CLI session of the winter offering. So our workshop last week on wills was rescheduled to April 6th in case anybody was registered for that one. Our CLI program is our series of legal information webinars, and we offer it twice per year on a variety of topics. So tonight we'll be talking about immigration law in Manitoba. This session is being offered in webinar format, so you are already muted and your cameras are off. The session is being recorded and may be posted on our website at a later date, but only the presenter views are captured within that recording. We will have dedicated time for questions at the end, but please feel free to use the Q&A function to ask questions during the webinar, and I'll be monitoring it throughout the presentation, and we'll try to get to them promptly. Please also feel free to let us know about any technical issues that might arise. So for example, if our connection's cut out or if you can't hear or see us. I'd now like to introduce our presenter and facilitator for the evening, David Davis. David has 31 years of legal experience with a focus in business investment and skilled worker immigration law, as well as family reunification. He recently graduated with a Master of Law degree from the University of Toronto Faculty of Law in the GP LLM program with a focus in innovation, law, and technology. David also has his law degree from UBC in Vancouver and his BA degree from the U of M in Winnipeg. David is a frequent guest speaker at the Canadian Bar Association Immigration Legal Conferences and the Law Society of Manitoba, a past chair of the Immigration Law section of the Manitoba Bar Association, and current chair of the Legal Research section of the Manitoba Bar Association. David has hosted many webinars for lawyers in tech law and legal research during the pandemic in particular. David prepared legal submissions and appeared before the Senate and House committees on immigration law, in addition to preparing legal briefs on behalf of the Canadian Bar Association National Immigration Section. He's the author of immigration articles and tech law articles for the Justice newsletter for members of the Manitoba Bar Association. And outside of practice, he's also an avid sports enthusiast, but mostly enjoys playing golf, downhill skiing, tennis, touch football, and floor hockey. So David is an experienced presenter, and we are so grateful to him for volunteering his time with us. So with that, I will pass it over to him.
Thank you very much for that great introduction. You probably heard dogs in the background. That's why I muted myself. My dogs were fighting in the background. So hopefully that won't be interrupting us too much. Part of the pleasures of doing Zoom when you're at home. So I have some topics that I want to go over, but I'm sure other people are going to have questions. Maybe you have some interesting cases that you're working on as part of your organization, and we can get into those questions in a little bit. But if you do have something that pops in your head and you want to put the question in the Q&A, that would be great. I think Victoria is going to help moderate that for me. And I really don't mind being interrupted, so all is good. So I usually like to start with immigration law as a main topic to basically remind everybody that the world with Canada immigration is divided basically into two parts. You have those countries where you're visa exempt, you don't need a visa to come here. And then there's countries where it's visa required. So examples of visa exempt, of course, are United States, England, France, Germany, most of Western Europe, basically. Most of the countries in South America and in Africa and in Asia are visa required. In Asia, the exception, of course, would be Hong Kong and Taiwan, South Korea, Japan, but most of the countries are visa required. And in fact, most of the planet is visa required. And this is where a lot of problems start, because you have countries such as India, Philippines, and China, where a lot of people want to leave. They want to come here. And it's very difficult because there's, 1.5 billion people in China. There's over 1 billion in India, and almost 100 million in the Philippines. Those are the top 3 source countries, by the way, for immigration. So you have a lot of people that are desperate to leave. And unfortunately, there's, many criteria that have to be met, and a lot of people don't meet that. And it creates a lot of havoc and a lot of frustration and anxiety on a lot of immigrants that are trying to get here. Immigration law is made up of the Immigration Act, the regulations, and then there's policy, operation memoranda, and of course OICs, which are Order in Council, which deals with the Quarantine Act. There's been over 75 OICs published since the onset of COVID-19, which primarily deals with what do you do with people that are arriving at the border, what are the rules that are in place, who gets to come in, who has to quarantine, who has to pay fines. There's the Contravention Act, which levies the fines for people that had a PCR test, it proved positive, but yet they still tried coming to Canada, and then they're going to be in violation of our laws. Then fines have to be levied and all the rest of it. So you have a lot of policy, you have a lot of operation memorandums, which are constantly being published by the immigration minister and also the Minister for Enforcement Measures, the CBSA, which is Canada Border Services Agency. So you really have to keep up. And with the advent of the internet, it's a lot easier to do so because things can be published in seconds, and everybody is basically using various social media tools to try to keep up with the latest announcements. So it's really important to bear in mind that although you have the main substantive law in the Immigration Act and the regulations, knowing what the policies are is almost as important, or if not more important, than what the actual Immigration Act says, because it's the policies that are the main driving force of our immigration programs across Canada. Now, I'm going to talk a little bit about family class sponsorships. I'm going to talk about appeals. Dixon, stop it. Sorry, everybody. Appeals to the Immigration Refugee Board, judicial review applications. I'm going to talk about the permanent resident skilled worker classes, provincial nominee program, express entry. I'm going to talk about delays in processing, what you can do to try to push a case forward in a much quicker fashion. Work permits, study permits, visitor records, and then the online portals on how to submit a case, and talk a little bit about artificial intelligence and immigration law. So that's a lot of topics. So let's get right into it. With family class sponsorship, there's, when you're sponsoring, for instance, a wife or a husband, there's marriage, there's common law, there's conjugal relationship. So marriage, everybody knows what that is. Two people get married. Common law, you have to be living together under the same roof, sleeping in the same bed for at least 12 months consecutive. And then conjugal relationship, it's basically a serious monogamous relationship, but there is no marriage and the parties have not lived together for at least 1 year. Conjugal partnership is actually very significant for mainly gay couples, I would say, that are from countries that it's criminal in that particular country for a gay partner to be married to one another. Countries like Indonesia and other countries like that. So they created the conjugal partnership category where two people have fallen in love, they want to sponsor their partner, but they can't do so because the laws in that country will not allow them to either get married or to live together. So the conjugal partnership has been a very good resource for people in that environment. Also, conjugal partnership can be used where two people can't live together. They might be a heterosexual couple, but the sponsor has a full-time job in Canada. They can't leave their Canada to be with their partner, to live with them for 12 months. And maybe there is something preventing them to getting married. For instance, in the Philippines, you cannot get a divorce. You would have to get an annulment. Annulments are very expensive and very difficult to obtain. So you could have somebody who is no longer with their married partner. They fall in love with somebody else from Canada. They want to be sponsored. So use the conjugal partnership category because there can't be a divorce, and there might be financial reasons why they can't afford to get the annulment. So that's some comments on that. There's also sponsoring parents and grandparents. Right now, the rules are, well, and they have to come out with a new announcement about sponsoring. So that should be coming out soon, if it's not already. I haven't noticed anything on that. But every year they have a quota. It's about 20,000 cases that they'll accept for sponsorship of parents and grandparents. And then you have to meet certain low-income criteria to be able to afford to sponsor your parent. And that's the main, I think, hurdle for many people to be able to sponsor their parent and grandparent. I'm going to move somewhere else in my house. It's very loud here. Okay, I'm back with everybody. Sorry about that. My young toddler was just entering the house and was not a happy camper. I noticed there's some bright lights behind me, so let me move over here. Maybe this is better. There. Okay, so I was mentioning about the low-income cutoff to be able to sponsor a parent and a grandparent. There might be a question. Let me go to the chat. Okay, I haven't missed any questions. Okay, good. I also wanted to talk about misrepresentations. Now, misrepresentation is very important to bear in mind with sponsoring a spouse. It happens many times. I don't want to explain about that. The main reason why a misrepresentation happens is a party may, for some reason, not want to disclose that they have a child from a previous relationship. They may not disclose that child because they realize that they need to have certain level of income to include that person in their application. So they will hide the fact that they have this child that was born clearly before they're immigrating to Canada. And they're thinking that if they don't disclose that child, they can just sponsor that child later on after they become a permanent resident in Canada. And that's clearly a misrepresentation. Section 40 of the Immigration Act talks about misrepresentations where there's a material fact that has been not presented in their application before they became a permanent resident. And I always advise clients that it's better to do the right thing. You acknowledge the existence of that child, or perhaps it's a spouse or some other material fact in one's case. It's better to present that information, because otherwise you could lose your permanent residence. I don't think people realize this, that when you immigrate to Canada and you've made a misrepresentation about something, such as the existence of a child or maybe a past marriage, they think that, you know, everything will be fine. Once I'm a permanent resident in Canada, I am solid. Nobody can kick me out of Canada, and that's simply not true. Even though you're a permanent resident, if you then later on try to sponsor that child or try to sponsor that spouse that you didn't declare, they're going to figure it out. And if you tried manipulating documents, they have fraud units in all these visa offices around the world. It's just not worth the risk. And if you do it and you don't listen to me, CBSA will take steps. They write what's called the Section 44 report, and they'll make a case against that person so that the end result is a removal order will issue, a deportation order, and then you're basically being kicked out of Canada for really no good reason. So I wanted to mention about misrepresentations for that reason. There's also appeals to the Immigration Appeal Board. If somebody tries sponsoring their spouse, they didn't have enough proof of relationship, the immigration officer didn't believe that they're in a legitimate marriage, then you can appeal that case to what's called the Immigration Refugee Board Appeal Division. The appeals will take roughly a year to be settled, but they are still, it's actually a great hearing to have, because unlike the federal court, you don't have to prove that there's a legal mistake that was made by the immigration officer. It's actually a fresh hearing. So you get to submit more information, more evidence about the legitimacy of your marriage, so you can have success in the appeal board. It really works well, and as long as you're properly prepared and you submit a lot of independent evidence, those types of hearings to the appeal board can be very successful. Then, of course, there's judicial review. Judicial review in the federal court is much more difficult. The timelines are very short. You only have 15 days to file a judicial review application of a decision made inside Canada. Whereas if the decision is made outside of Canada, such as a work permit refusal or a study permit refusal, the appeal period is 60 days. Now, unlike the refugee board, with federal court, you do have to prove that there was some mistake in law or mixed fact in law, and it's very difficult to win a judicial review application in the federal court. So that's why when somebody asks me, you know, preparing a work permit is quite easy, what do we need a lawyer for? Just bear in mind that if you are refused that work permit, your chances of success in the federal court is going to be very, very difficult to prove, because there's just too many cases where you're applying for leave to appeal to the federal court, and the federal court just doesn't have enough time to hear every single case. So a lot of them are dismissed, and there's no leave application that proceeds further into the process. Then there's permanent resident applications on the skilled worker class. So the skilled worker class, mainly there's provincial nominee application cases and there's express entry. The main difference that I would say, one over the other, express entry is great, but you have to work 1 full year and you need an English test result of at least 7s on the CLB scale, which can be very difficult. That's very good English if you're getting a 7. People that will use the provincial nominee program are applicants where they don't want to have to work a full year. The requirement is only 6 months work. And actually, it's even less if you're an international graduate and you get a high-skilled job in your field of study, such as an engineer. You don't even have to have any work experience in Canada. You can make an application to the provincial nominee program immediately after graduating, as long as you have that job offer working in a high-skilled field. And provincial nominee, there's high-skilled cases where you don't have to submit an English test. There's low-skilled cases where you do have to submit an English test. I have found that a lot of the low-skilled jobs, such as truck driving, you have to practice your English. You have to do well in an English test because, being a truck driver, I think, is a very important skill to have. It's part of the supply food chain that makes this country operate. But if you don't have good command of the English language, you're simply not going to have a good application to submit to the provincial nominee program. Then there's Canadian work experience for those applicants that have gone to universities and they want to apply to the express entry profile. Having Canadian work experience of at least 1 year is absolutely critical, and also having the English test result, like I said. Now, what I found in the last couple of years because of COVID is the delay in processing. It's not uncommon that applications have been pending for many, many months, if not years. And I think one of the great resolutions that has worked for some of my clients is bringing a Mandamus application in the federal court, where you prepare an application record and you argue that your case has been pending for a very long time. I would say at least 1.5 years would be significant enough to lay the foundation for submitting a mandamus. And mandamus can work because you're getting the immediate attention of Immigration Canada, because they have to hire their lawyer, which is Department of Justice. The Justice Department gets involved. They have a lot of things on their plate. They'd rather not spend and waste time answering this application. So they get in touch with their client, Immigration Canada, and they tell their client, hey, get this application moving. The applicant's lawyer has submitted sufficient proof, credible proof, that there's a legitimate application that's been pending for many months. There's no reason why it's being delayed. They pass their medicals, they pass security checks. It seems to be languishing in cyberspace, so get the application moving. And it does work. It gets the attention of immigration, and things will be moving much faster. So that's what I would submit is a good tool to use. Work permit applications, I would say one of the most common reasons why a work permit's refused, it's just not documented well. You got to have a job offer letter. You have to have proof of English ability, especially if it's an important aspect of the job. You have to make sure that you're submitting credible documents. You have to submit sometimes affidavits proving your work experience. Many countries like India, people will work under the table because their employers don't want to have to pay taxes. They don't want to have to report incomes to the government. So they hire workers. They're legitimate work, but the worker doesn't have proof and their employer doesn't want to submit a letter of reference. So what do you do in lieu of that? You prepare an affidavit where the applicant is telling the truth that they really did have these jobs in India. This is very important because to get a work permit in Canada, if you're going to be working, let's say as a truck driver or as a meat cutter at a meat cutting place in Canada, you got to prove experience. You have to prove that you have the abilities that are required of the employer. And, preparing and well documenting a case will make it very difficult for the immigration officer to refuse the case. And the decision of the immigration officer has to be intelligible. They can't just refuse a case and not give sufficient reasons. And getting those reasons is very important, especially if you want to lay the foundation for a possible application to the federal court arguing judicial review should be granted in favor because the decision wasn't intelligible enough to be accepted by the court. Then there's study permits. I would say two main reasons why study permits are refused. The applicant doesn't demonstrate sufficient financial background, and the study plan was not properly prepared. A study plan is needed because you have to be able to establish to the satisfaction of an immigration officer that you have a legitimate reason why you're coming to study in Canada. You can't just show acceptance to University of Winnipeg that you're going to study in this program, that you want to make yourself a better person. You have to go beyond that. You have to explain, why aren't you getting this degree in your home country of India? Why do you feel the need to come to U of W? So you have to be able to prove to the satisfaction of Immigration Canada that you have a well thought out study plan. I would say a study plan should be at least 2 to 3 pages long, if not longer. You can also express it by way of an affidavit, because in an affidavit, you're swearing to tell the truth or you're affirming to tell the truth. And immigration officers like to see that because it demonstrates to them that the person has really thought long and hard as to the reason why they want to come to Canada. Then there's visitor records. The basic element of a visitor application, you have to prove why you're coming here. Did somebody invite you here? Why are you coming? And most importantly, you have to prove that you're going to go back to your home country. You can't just say that you're coming to Canada for 2 weeks or maybe 2 months. You have to be able to prove that if you had a job in your home country of India, that you have the consent of your employer to leave that job for a few weeks and to travel to Canada. You're going to go back to that job after you visit your relatives. Maybe you're coming here for a family wedding or a big party. Somebody's graduating, somebody gave birth. There's a birthday happening for the new child, relative in the family. There should be some legitimate reason that the person is applying for a visitor record to come here. Online portals, everything, almost every single application is now submitted online. It's very rare that you're going to submit something by paper. In many ways, this is a good thing because the whole idea of the online portals is to make the cases processed in a very expeditious manner. Everybody wants something done yesterday. I've never had a client hire me saying, oh, take all the time in the world. They want something when by the time they've engaged the lawyer to do something, they've already thought long and hard, and they want, they want the action to happen very quickly. The thing with online portals is sometimes there's technological problems. Sometimes the portal's down. So if somebody has a work permit that's expiring today at midnight and you're trying to submit it on the same day and the portal's down, oh my God, what do you do? Well, you take screenshots of your attempts to try to submit it. And if you are late, the government will recognize that and not penalize you by refusing your application because you submitted it late. They'll see that you've honestly tried to submit it in time. With the online portals, you have to create, just like you would if you're setting up a Netflix movie account, you have to have login details, you have to have a password, you have to set up questions that you would be asked in case they want to identify you properly, because there is a lot of cyber attacks on the internet. So it's a very, they try to make the online portal as secure as possible. What I have seen in the last couple of years is artificial intelligence is making headway in immigration, especially with visitor visa applications. I can tell when I get a decision on an application, it looks like it's artificial intelligence. You can tell that there was no human being behind the scenes making the decision because maybe the wording in the letter is so brief and unintelligible. And I think this is a real problem with Immigration Canada because it's merely going to make lawyers like myself resort to the federal court system to seek justice for their client, because if you are going to use artificial intelligence, you still have an obligation to make sure that the decision being made on an application is complete and intelligible. So that's very important for people to know. That's basically what I wanted to go through. I sort of ripped through it very quickly. Maybe I talked too fast, but Vicky, I'd like to entertain questions from the audience now. Anybody have questions? No open questions. Is there some topic that people want me to focus on that, let's see what this is. Would asking for a visitor visa to get a relative over to help care for a senior family member here be legit? Yeah, it's a great question. So it's not really a visitor visa, because you're coming for probably an extended period of time. I'm sure that that senior family member is going to need care for a lot longer than a few weeks or a few months. Now, that's one argument, but if there is no other relative that's around, or maybe for financial reasons, there's no ability to put that person in a care facility, or maybe you don't want to put that person in a care facility, especially with what's happened with a lot of these homes during COVID, then you would make that case. You would make the argument and say, look, I need a visitor visa that's going to cover, let's say, 5 years, because I'm coming to Canada to care for this senior relative. I have enough money to cover my own expenses. And you'll have to, submit documentation about that senior. You'll have to submit maybe documents why there's nobody else to assist with that senior. So on the one hand, I'm pointing out that it's going to be a very extended period of time, but if you can prove through financial documents and the legitimacy of that relationship with the senior, then you could possibly have success with that visitor visa. I hope that answers your question, Sam. Vicky, are people able to talk as well? Is there audio or no?
I'm not sure if the function is available to unmute. I think that if someone were to raise their hand, I might be able to unmute them. We do have another question in the Q&A. Oh, we have 2 more questions. Sure. So I'll go with the one in the Q&A. Sure. This question is about a refugee process rather than immigration process. Sure. I know a refugee who has been here for several years and is still trying to get his wife here from Ghana. Would the Mandamus option work for him? She is in hiding due to the government trying to get to them.
Oh, so okay, so the person, okay, so the main applicant is a refugee. They've already been declared a protected person, and they have a spouse who's living in Ghana, and the spouse fears the government of Ghana that they're currently living in. Do I have the facts right?
That's my understanding. Yeah, we've got confirmation. That's the,
okay. Well, number one, if they're fearful of the government of Ghana, does that person not have the ability to leave and go to a neighboring country? That's Myrna asking, I guess, right? Myrna, did you hear my point? She has, but this has been going on for years. Yeah, that's a complicated case. Well, now to answer your question, mandamus would work. I think that, yeah, I would definitely argue mandamus. I think maybe another issue in the case is the legitimacy of the marriage between the husband that's here and the wife in Ghana. Maybe it hasn't been well documented. I would look at that. I would look at the existence of a marriage document. I would look to make sure that any documents that they've submitted was properly prepared, and if needed to be translated, it was translated properly. But if this case has been going on for years, I think preparing a mandamus application would be important. And I have actually done it for protected persons before. I actually have a case where the husband, he's been in Canada for over 8 years. He's a protected person. He still doesn't have permanent residence. And there's really no legitimate reason why it's been dragging on. So we brought mandamus and we're getting the case moving. He hasn't been declared a PR yet, but we were just hired a couple of months ago. But there is some positive steps going in the right direction. But Myrna, that's a really complicated case. And, you know, I'm going to put my email address for you and for everybody in case you want to email me and we can talk offline maybe later this week or next week. That would be my email for, I would say, complicated cases like this. Now, somebody else said, what documents are required for my pregnant wife to have a visitor visa for her mother? Okay, so wife is pregnant, due to give birth soon, wants to have their mother here. What documents are required? Well, I would definitely submit a document from their doctor proving that they are pregnant. You know, believe it or not, people will lie about everything. So the more documents you have that proves every element of a case, the stronger it'll be. So she needs to prove that the mother she wants to invite on a visitor visa truly is her mother. You want to prove so birth certificate information. I'm not sure which country the mother is from, but you want to bear in mind, you know, maybe country specific documents that might be required. For instance, somebody from Nigeria, you want to know what's the you know, the relationship between the mother and the daughter. Have they been communicating a lot lately? So maybe submit proof of their communication, that the grandmother wants to be actively involved with the assistance in delivering the baby and to be at home with their daughter. So those are the things that I would prepare. Hope that helps.
We have another question as well that got buried a little bit, just to come back
Okay.
to before we get too far away from it. Regarding the visitor visa for the relative with the care for the senior family member, that
Yeah.
person's followed up to ask if there's another option other than a visitor visa for that situation.
Well, if it's a senior relative like a mother or a grandmother, then obviously sponsoring the parent would be one option, but I'm assuming it's not a parent or grandparent. There really is no other option. I can't think of anything else, or sorry, I guess the senior relative is here and the person overseas. Well, maybe, okay, maybe in-home caregiving. So there used to be, the application was called live-in caregiver, but they changed it to in-home. So there's no longer a need that you actually physically live in the same house as the person that you want to care for. So that involves a labor market impact assessment. So this senior relative would essentially be the employer of the relative abroad that wants to come to Canada to help care for them. So that's a possible application that could be made. And, you know, we can talk offline about that another time if you'd like.
Perfect. Then maybe we'll go to the Q&A questions. We have one from someone who's asking, in your experience, is it hard for young unmarried men to come to Canada for a visit as opposed to, for example, a retired grandparent? Could you offer some advice on what could strengthen such an application?
Young unmarried men to come to Canada for a visit. Okay, well, yeah, I mean, that's a good question. Unmarried men, young, I mean, I guess if somebody is unmarried and they're young and they're single, I think the best application to apply for is a study visa that, have them come here. They want to get a university or a college education because the education standards are so high and so good in this country. And they want to be educated in Canada because if they are going to return to their home country later on, they'll have much better chances of getting a much better job in their home country as opposed to not having that Canadian education. I would think that's probably the better way for that person to come. If they're just applying for a visitor visa, it's going to be very difficult because they're young. I'm assuming their work experience is either very brief or negligible. So it's going to be hard for that young person to prove that they're going to return to their home country after coming here for a visit. Hope that answers that question.
And we have one more in the Q&A. It's a little bit different. What would you recommend for someone wanting to enter the field of immigration law? I have experience working with skilled immigrant professionals.
Well, I guess they're wondering, is it a good field to work in? I think it is. I think it's very rewarding. It's very interesting work. You meet people from basically every corner of the planet. You get to expand your horizons, I think, in many ways, because in immigration law, there's many other areas of law that intersect with it. There's criminal law, there's tax law, there's family law, there's corporate commercial law for business cases. So yeah, if you have experience working with skilled professionals, I think it's a great area. I don't know where we're at with the consultants program. I know that there's a new program that's based at Queen's University in Kingston for consultants. There's a whole new standards that are set up. And then of course, there's going to law school to become a lawyer and you can work in that field. But yeah, I can talk to that person another time if they wish to email me, and we can talk more about what interests them in immigration law. Sure.
Perfect. And then we have one more question that just came in.
Yeah.
Have you heard anything about Afghanistan refugees or about the Ukraine as the situation in Ukraine? I guess there's some inquiries coming in about those situations.
Yeah, I don't do a lot of refugee law, but I do know that the Canadian Bar Association, because of the crisis in Afghanistan that, well, it's been going on for many, many years, but of particular note, once United States and Canada pulled out at the beginning of September, we've created a pro bono panel of lawyers across Canada, which is giving free legal advice to refugee clients that might need some legal help with their applications out of Afghanistan. With Ukraine, I'm really not familiar at all, but I would say that the same program would not be restricted just for Afghanistan people, but also for Ukrainians. So there are these programs that the Canadian Bar Association sponsors. I'm actually not part of that panel, but I certainly don't mind, sharing some experience that I might have, which may help in a particular situation. So if we have people that are part of this webinar today that are part of special interest groups in Winnipeg and they want some ideas or direction, I certainly don't mind meeting you on Zoom or talking on the phone about particular legal issues that you're experiencing. And if you have a particular legal issue or scenario, please ask that question now, because I think that other people may want to hear about that. The contact info, I don't have it in front of me, but if you visit the Canadian Bar Association website and you go to the immigration section, I believe there's a notification there with the legal assistance that we're providing for Afghanis.
I'll take a look as well right now, and I'll see if I can put that in the chat.
Yeah, if you could. I should know the answer to that, and I'm sorry, I'm not involved in the program at all, but I have colleagues that are involved in it. I could even I could give you a couple of emails, actually. Lawyers that are familiar with it.
Here we go. This is the website as well. So
oh, did you find it?
Yeah.
Yeah, there you go. Excellent. Yeah, I would visit that link that Vicky had time to look up. Because I think, I can't remember how many lawyers are involved in it. It's not a large group, maybe 10 to 20, but they're lawyers that are very familiar with what's going on. So I think it's an excellent program. Good pro bono work.
And I see that we have a question in the Q&A just for your email address again. I'll just copy and paste that as well, because I see that you would put that
in the
chat, so that we have that here as well.
Yeah, and maybe somebody has another question, but maybe they're shy to ask it in chat. That's fine. Please email it. I've got a particularly busy day tomorrow, so I might not answer until Friday. But please do that. Vicky, I talked very quickly. Maybe I was too quick. But I actually wanted to mention something out, and this is on a criminality front, because maybe people in the audience have heard about this problem, and that is people convicted of impaired driving in Canada. Impaired driving used to be considered what we call a simple criminality. It wasn't serious, because the maximum jail sentence used to be 5 years. But then the law changed in December of 2018, and it then was elevated to what we call in immigration serious criminality, because the maximum jail sentence was increased from 5 years to 10 years. And because of that, somebody who's a permanent resident in Canada for, let's say, 20 years, makes one mistake, gets caught for impaired driving, pleads guilty, gets a fine, they'll be called by the enforcement unit of CBSA and invited to a meeting. Of course, a lot of these meetings are done on Zoom now. But the long and the short of it is they may be removed from Canada because of the single conviction of impaired driving. Now, I know impaired driving is a very serious offense. I agree. So I certainly don't want to enter into debates on that front. But the ramifications for immigrants is very different than the ramifications for a Canadian citizen. Being forced to leave Canada and go to a country that you may not be familiar with anymore, I think is a very big deal. And there's very little that can be done now. So I always tell my clients, and I have many now who have criminal defense counsel, to contest those charges and do your best to try to win your case in court. Otherwise, you're going to be facing the possibility of removal from Canada, even if you've been a permanent resident for 20 years or more in Canada. So I want people to be aware of that. I'm not sure if that creates more questions.
Thank you. That's so important.
Oh, Syrian refugees. I'm not sure what you want me to talk about Syrian refugees. I've had clients from Syria. I think the government a few years ago had a very good program where they were sponsoring groups of people from Syria. Maybe, Lisa, there's a very specific question you have related to Syrian refugees. Please tell me. Has she added anything in the Q&A? No?
Not yet. You'll give just a moment in case anybody's
I
typing.
think the main thing with any refugee case is you want to try to make sure that things are documented as best you can. And I know that's a tall order, especially for people that are leaving a country where there's a lot of, there's a war going on, civil war, what have you. But having documents is just so important. Whatever you can, that's the most important thing when you're making a refugee claim. And of course, getting your story straight. You got to be able to express yourself, even in your own language. I mean, the government will provide free interpretation to you, so you don't have to worry about the need to express it purely in English or French. You can do it in any language, but you have to have a credible story that you're making. And it's got to be your own story. I've heard cases from Montreal where they hire certain consultants and they have like prepared scripts that they just regenerate and sell to people. And it's disgusting. Obviously, I'm not advocating anybody should be doing that. And that's why, if there weren't cases like that, I think we would probably see more approvals of refugee cases. But unfortunately, the bad will affect the good. And like I said earlier, when you have visa required countries, visa exempt countries, people from visa required countries are going to be desperate. They're going to turn to dealing with people that are making money, giving false information or false hopes. And unfortunately, that's what we're faced with every day as immigration lawyers.
We do have a follow-up to the question about Syrian refugees, specifically wondering if you're still seeing a large influx of Syrian refugees.
No, I haven't personally. So I really couldn't comment on that. Sorry.
Looks like we don't have any other current questions in the Q&A or in the chat, but we still definitely have time if anybody would like to add any questions. But also this has been so helpful too, with so much really wonderful information and really important information. So thank you so much for sharing everything so far. Oh, we have another question here. Is there an expectation that the backlog created by the pandemic will be cleared within 1 year?
Great question. I think the current immigration minister just has so much work on his hands. I don't know how he's going to get through it, which is why I think Mandamus applications are going to become more common, because there's just such an incredible backlog. And I remember years ago, I think it was about 15 years ago, there was a backlog with federal skilled worker cases. And what the government did is they just refused everybody, didn't return their money, and created a new program thinking that people would just apply under the new program. Well, what happened was a group of lawyers got together and brought a class action against the government, and they won. And the government application fees that people had paid had to be returned to them, and we're talking millions and millions of dollars. So I don't think the current immigration minister, if he's smart, and I'm sure his staff will remind him what happened 15 years ago, they can't do that. They can't just cancel somebody's case merely because there's a backlog. They're going to have to do something about it. Either they're going to have to make a new policy that possibly addresses that backlog in some interesting, innovative way, or they're just going to take their time with the applications, thinking that, well, if this person really is serious about it, they're going to hire a lawyer and bring a mandamus application. Of course, hiring a lawyer, bringing a mandamus costs money to the applicant. People don't want to have to spend money that they don't otherwise have to try to pursue something. But let's face it, if you're going to become desperate enough and you're not going to be able to renew your work permit, or you're not satisfied with that, let's say you want your permanent residence because you want to sponsor your mom or your dad from your home country. You can't sponsor them if you're merely on a work permit. You need permanent residence. So getting permanent residence is going to be really, really important. And I think over the next 12 months, it's going to become so bad. I think the government's going to try to think of innovative ways to deal with it. I can tell you, as a member of our national executive with immigration lawyers across Canada with the CBA, we are having meetings with the government and we are trying to come up with policies ourselves. For instance, we want a post-grad work permit policy to be a little bit more lenient to help those who have graduated have an extension of their postgraduate work permit, because many people, let's say in the food industry, lost their jobs because restaurants closed due to the pandemic restrictions, or nobody wants to go to a restaurant. And really the only restaurants that are doing well are selling hamburgers and pizza. And any like well-groomed restaurant that prides itself on the quality of the food they're serving needs servers and needs cooks, and they're not doing well with the pandemic restrictions. So you have people losing their jobs, or maybe temporarily laid off, or their hours were cut in such a degree that they're not going to qualify for another work permit. They need that open work permit. They need it to be extended to give them a helping hand to get permanent residence done. So these are some of the things we're working on.